Everyone, it's me, and I'm back with another Ask Asha. This week, I thought that I would talk about how to think about presidential power, especially since we are now witnessing a vast expansion of claimed executive branch authority in a lot of different areas. And to sort of understand the legal underpinnings of this, I think it's worth revisiting a 1952 Supreme Court opinion called Youngstown Sheet and Tube Company versus Sawyer. You might have heard of this case as the Youngstown case or the steel seizure case. It was a case that arose out of President Truman's attempt to seize steel mills in order to prevent a strike of those steel mills during the Korean War. Now, the problem for President Truman is that no statute authorized him to do this. He issued an executive order authorizing his Secretary of Commerce to do this under his Article 2 Commander-in-Chief authority, his war powers, because he said, we need the continued production of steel in order to fight this war. But the statutes that did exist, Congress had thought about giving him this authority and had decided not to. So there was nothing on the books that officially gave him the authority to do this. And this case is really interesting because, first of all, the Supreme Court, just spoiler alert, said that he did not have authority to seize those steel mills. But that case is mainly known for a concurrence by Justice Robert Jackson. And Justice Robert Jackson is basically analyzing this case, and he offers this really interesting framework in order to assess claims of presidential power. And this is kind of known as Justice Jackson's framework. You'll see court cases invoke this in a lot of different contexts. But basically, he says that there are three tiers of presidential power. When the presidential power is at its maximum, when it's acting at its most robust, in its most robust form, the president is acting in concert with Congress. In other words, you have the president's authority plus Congress is giving him authority as well. And this is sort of the most power that the president has. So this, for example, could be when Congress declares war, and then the president is also exercising his war powers. He has basically the full authority of the sovereign nation, the federal government behind him. The second tier is where Congress is silent. They haven't legislated on a particular issue, and it might be an area where there is some shared power. It could be things like foreign policy, where it's really unclear based on the constitutional text where one branch's power begins and one ends. And Justice Jackson called this the zone of twilight. Not to be confused with the Twilight Zone, which is also what we're living through right now. But the zone of twilight is really interesting because it's a place where the court really looks to see the specific circumstances of the claimed power. It looks to see whether it's something that the executive branch has historically done. Has it been doing this without any objection from Congress? And if so, has this become sort of a part of the, accrued powers of the presidency? And then the third tier is where the president is acting against either the express or implied will of Congress. So, for example, in that steel seizure case, Congress had considered giving the president authority to stop strikes. They didn't. So impliedly, that was not something that they had wanted to allow him to do. In those kinds of cases, the president can only rely on his Article 2 authority. In other words, he has to be able to go to the Constitution and look at Article 2 and say, the document gives me the power to do this. And so you can kind of imagine Justice Jackson's framework as being an inverted pyramid, where you have a more expansive power when he's working in concert with another branch. There's a slightly lower when it's uncertain and we're in this zone of twilight. And when he's relying on his Article 2 authority, it is really a relatively narrow set of powers that he can do that no one can question him on. And this seems pretty consistent with the idea of separation of powers, that, the idea that each branch has certain things that the other branches can't ever intrude on is relatively narrow, because we do have checks and balances that, operate among these branches. The reason that this framework is really important is that what we see with the Trump administration is really an attempt to expand that third tier and kind of widen it to make it almost, I would say, as powerful as when he's acting in concert with Congress. Maybe even trying to invert it and saying that it's even greater than, what Congress can authorize. We see this in a number of different areas. So, for example, Trump is claiming Article 2 authority, his executive branch authority to hire and fire officials, even where Congress has passed statutes that say that people can't be fired in certain agencies. He's claiming Article 2 authority to abolish agencies themselves when Congress has created those agencies. He is claiming Article 2 authority to not enforce laws at all. I did an Ask Asha about the TikTok law, and Trump is simply not enforcing it. And what is he claiming? He's claiming national security and foreign policy. It's those, core executive branch powers. And so it's really important to pay attention to what Trump and the executive branch is claiming. And you'll hear this a lot, by the way, from the Department of Justice. Most recently, Pam Bondi fired the interim U.S. attorney that was appointed by the courts because there was no one in that position. Alina Habba in New Jersey had exceeded her temporary position. A statute gave courts the authority to appoint someone, and Pam Bondi fired that person and said, I don't have to honor anything that interferes with the president's Article 2 authority to choose who serves in the Department of Justice and in these positions. So there is this claim being made of a very expansive Article 2 authority. And the reason that this is especially important is because, all these people are claiming to follow the law and to follow the Constitution, but their interpretation of the Constitution is one that envisions a much more robust executive branch power than what we've imagined. And right now, we are in a place where the majority of the justices on the Supreme Court actually sign on to this view of executive power. And so what we can expect, unless there is some effort to stop it in some way, and I'll save that for another Ask Asha, is an accretion of power in the executive branch from and weakening Congress, weakening the courts. And of course, in common parlance, we see this as authoritarianism, really. And so pay attention to the words that are being used. Remember Justice Jackson's framework and think about whether it's being applied by the Trump administration today.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.